Hello everybody. So in this short presentation we're going to look at what the courts have ruled concerning student discipline. And as we will see, the majority of this is really going to concentrate around the concept of in loco parentis. And as Alexander and Alexander point out, in loco parentis is a very important and vital idea in school law. And this is saying that as teachers and as principals, we are in essence acting as the parent of the child. And so as a result of that, when the child is in the school setting, principals and teachers can use their discretion as the parent to maintain order in that school setting. We're going to talk about policies in just a minute, and if you've had me in other classes, I talk about policies all the time, the importance of policies. We have to have policies. But before we get to the policies, just know that this concept of in loco parentis does give school officials great latitude when it comes to child discipline. Alexander and Alexander state it has historically been held by the courts that there exists on the part of the students an obligation of civil deportment, obedience to reasonable commands, and a respect for the rights of other peoples. Teachers have an inherent duty to see to it that good order is carried out. As a result of that thinking, courts have given much discretion to school leaders in discipline issues. As we've said in earlier videos, when it comes to discipline, the courts have really said that school leaders and school teachers know more about the context of what's happening inside the building, and they are not going to be the ones to dictate the day-to-day stuff that happens inside the building. And so based on this idea that teachers have an inherent duty to see that good order is carried out, they're going to rely on the discretion of teachers and administrators for the most part. Where this comes into play is the reasonableness and again the policies that are enacted. So reasonable rules. School discipline rules have to be reasonable. And there are two criteria for this. The rules have to be motivated by reason and humanity on desirable educational outcome, and that the teacher must act in good faith and enforcing the rule. And hopefully you don't deal with this as an administrator, but you know, one of the tough things to do with working with teachers, and I've had these conversations in the past with teachers, is that teachers will sometimes allow students to get under their skin, to not use a good analogy, but you get the idea. And I think they start to go off of that good faith. And you see this in simple things like teachers disciplining students for not bringing a pencil to class or something. You know, these are things that Harry Wong taught us years ago. You can institute simple procedures. But I remember having a discussion with the teacher, and I said, if this were your child, would you have sent this child down here for this very thing? And the teacher had to step back and think a second on that. And so the rules we have generally are going to be motivated and follow the first criteria. Where you as an administrator are going to come in and be a leader is when you're working with teachers on that second criteria, and film deciding punishment or discipline actions. So one of the biggest things then when we talk about punishment, here we're talking about discipline of sending a child to the office and so forth, which would result in a phone call, letter home, blah, blah, blah. But in the big picture of school discipline, one of the things that Alexander and Alexander concentrate on is corporal punishment. So the foundation case for corporal punishment here is Ingram versus Wright, 1977. And in that case, the courts ruled that corporal punishment was legal. Leaders have to take into consideration 5 things before administering corporal punishment. But once these things are there, then it's legal. Number 1, the seriousness of the offense, the attitude and past behavior of the child, the nature and severity of the punishment, the age and strength of the child, and then finally the availability of less severe but equally effective means of discipline. Once all those factors are considered, then corporal punishment can be administered. Corporal punishment is legal in Oklahoma, but we are an exception to the rule. Most states have outlawed corporal punishment, and in doing some research when I was in graduate school on corporal punishment in Oklahoma, one of the things I learned was that corporal punishment, when administered, tends to be administered by male administrators in their first few years of being a principal in rural areas of the state. Those are predominantly the people who administer corporal punishment, which was an interesting insight into corporal punishment. I did as an administrator, it was during my term as principal, that we as a system in the school district in which I was employed decided we were going to stop administering corporal punishment. So even though it was legal, we decided to stop doing it. One of the reasons that we see districts back off is this next slide, and this is assault and battery. Even though corporal punishment is legal, excessive use of it may result in charges of assault and battery. This could be a criminal case or this could be a tort case. And we've talked about what torts are. But either way, this can get ugly for the district and certainly for the teacher and or administrator involved. Criminal offense means that you could be sued in court and forced to pay a fine. And if it becomes felonious, you could lose your teaching license in Oklahoma for 10 years. A tort offense means that you're going to pay damages to the plaintiffs if found guilty. So it becomes a very ugly mess very quickly if done incorrectly. So just a little bit more about Ingram versus Wright, the 77 case that brought all this about. There were 2 questions here. The 8th Amendment, was this cruel and unusual punishment? And then the 14th Amendment, the Due Process Clause, are children guaranteed a right to due process. And in both instances, the court said no, the child's right in this case was not violated. It was not considered cruel and unusual punishment, even though we typically see that in prisoners as opposed to school settings. And the 14th Amendment rights of due process were not violated. Though there was a caveat that once the line of excessive corporal punishment is crossed, there may be an issue of substantive due rights violation, and this involves the legal phrase that Alexander brought up, the shocking to conscience idea. shocking to conscience is a legal lens to view corporal punishment. In the case of Ellis versus Cleveland Municipal School District, and notice this is a circuit decision, this is not from the court, the Supreme Court, stated shocking to conscience was inspired by malice and sadism rather than overzealousness of the school officials. So shocking to conscience is the idea that the punishment administered was so severe and so out of line that it shocks the conscience to see it. What the Sixth Circuit Court here is saying in Ellis is that an overzealous administrator or school official does not necessarily result in a shock of conscience. They go deeper in looking at what inspired the corporal punishment. Was it malice or a sadistic vein in the administrative punishment? And if that's the case, then they would rule for the student. The Fifth Circuit, on the other hand, has taken a different stance, and they basically say there is no shock to conscience as long as there are remedies in state law. And remedies being, could there be a criminal or could there be torts? And if those cases are in place, then there is no shock to conscience, no matter what the corporal punishment is. So the Supreme Court really hasn't dealt into this, and after reading Alexander and Alexander, this again looks like a place the court is really going to leave a lot of discretion to the schools. Where we see schools starting to come into court, and this whole reason for this shocking to conscience and what corporal punishment, whether it's legal or not. So Wainwright was in 77. All this comes about after the early 70s with the Child Abuse and Prevention and Treatment Act of 1974, which created the National Center for Child Abuse and Neglect. As a result of this, this is when courts started looking at corporal punishment and trying to decide if corporal punishment was child abuse. And again, as we said, courts generally rule in favor of school districts, though this again brings into the question what excessiveness means. It is also with this law, the Child Abuse Prevention and Treatment Act, that we get mandatory reporters, as you and I as school officials are considered to be mandatory reporters. So we have to report when we suspect child abuse. And unfortunately, I've been in that situation where I had to make those reports. And I hope that you don't ever get into that situation. But so this is part of the laws that school leaders who administer corporal punishment can be sued under as far as a criminal case, the Child Abuse Prevention and Treatment Act. So again, while corporal punishment is legal, it starts to become very muddied very quickly. And honestly, I think probably part of it is due to my age. As I found in my research, like I said, it was young administrators. I tend to rely less and less on corporal punishment and suggest more counseling and work with the students. So what kind of other infractions can we discipline students for? How about off-campus infractions? Off-campus infractions, there has to be a connection to the general order of the school, and school officials can discipline students for an off-campus infraction. Examples of this given in your book are students who were blocking school buses, students who are bullying other students walking home from school, and that kind of stuff. These are off-campus infractions that schools can legally discipline a student for. Of course, any type of field trip or athletic competition or academic competition that a child is participating in as part of the school activity, that child is definitely under school disciplinary. So how about the internet? So this, we will have a section on social media. The courts are really, there's a lot of openness on the idea of the internet and where courts stand. The thing that Alexander and Alexander point out is really it comes down to, in my opinion, the Tinker decision and how what is put out on the internet disrupt the school environment. Remember the Tinker case from the 60s and disruption of school environment. So the other question that the authors bring up deals with free speech. So if you put if a student puts something on the internet and it's being talked around schools and students are discussing it during class and the teachers report they're not being productive, then that has obviously disrupted the school learning environment. So that passes the Tinker test. But what about the free speech? What if a student were to create a website or put something on social media that disparages a teacher or an administrator, and it is not shown to disrupt school? It's the student's private page and the student shares it with somebody. Here the courts have ruled that generally free speech is free speech, and we see them being a little bit more lenient with students on that issue, especially if we see that it's not disrupting the school. So the internet, in my experience working with schools, the thing here as an administrator is, we're going to talk about policy in a minute because it's all about policy, but really you have to show that nexus where what students have put on the internet is causing disruption within the school. And at that point, if it is in your policy, you have the right and the ability to intervene. What about cell phones? So cell phones, kind of like the internet, have become ubiquitous at a much faster rate than the courts have been able to make decisions. And so there are a couple of general rules that we see regarding cell phones. And I think this is changing all the time, how we treat cell phones in schools. I can remember when, obviously, there weren't cell phones. Then we got them, we restricted them, and now we're trying to encourage students to use them. So when schools have policies in place for cell phone use, here are things to remember. School leaders can confiscate cell phones. They can ban cell phones. What they cannot do is go through the cell phone and look at information that is stored in there or ask the student to show them that information. Okay, that is still private, and that would be a violation of the student's Fourth Amendment rights. So, moving on. How about discipline for academic purposes? Academic discipline for academic offenses is considered legal, generally upheld. In other words, a child is given an F for cheating, suspended for plagiarizing a paper, etc., etc. These things must be defined. Once they are, they're generally accepted by the courts. So here's part of the policy piece I was talking about earlier. You have to have this stuff in policy, or when your teachers are giving assignments, they have to have this stuff and show that students have been given information of what would result in an academic infraction And for that reason, they can make an academic discipline move. Where I think school leaders come into problems is when they try to do academic discipline for non-academic offenses. And I think this is a tough area when you consider things like suspending students, and this is just my personal opinion, but when you're suspending students for non-academic things, suspension in itself then becomes questioned, but when you're suspending students, you're taking them out of the academic realm. So is suspension for a non-academic, let's say a student got into a fight and you're suspending the student, you're going to kick the student out of school for 10 days. That's a non-academic infraction. Are you imposing an academic discipline on that student for a non-academic infraction? And I think that's an interesting area to examine and to see. In my experience as principal, what we see is the students who are typically suspended are the ones who can least afford the academic discipline, such as removal from school. So it's an interesting thing to consider moving forward. I don't have an answer for that. I'm just throwing that out there for thoughts. And finally, how about zero tolerance policies? Well, we have lots of zero tolerance policies in our country right now, but what about specifically schools and zero tolerance policy in schools? So the courts have ruled, and when we mean this, zero tolerance meaning a disciplinary action. In other words, if you are caught with a knife and it says no weapons, automatic suspension for 6 months. No matter what, you're out 6 months. Zero tolerance policies do not deny due process. What they do is they prescribe non-negotiable penalties. Okay. Here's what the courts have ruled on zero tolerance. Basically, they're accepted. The idea of acceptance here for zero tolerance is that they have to be clearly publicized and for specific offenses. They can't be blanket statements. They have to be clear what the policy is for what offense. And the students have to be made aware of the policies. So there has to be a way in which students are made aware of the policies. In some courts, the majority of courts do not take the knowing and unknowing and intent into consideration. Some courts have upheld the interpretation of zero tolerance policies through the lens of the knowing or unknowing and intent to harm. In other words, zero tolerance policy being that a student has been accused of an infraction but did not know. For example, Alexander talked about a girl who was a good student who had a cup of beer in her vehicle from her parents the previous night and did not know about it. The way I read the text, most courts are not going to take that into consideration, but some will. And this idea of scienter, or knowing, could be taken into consideration on something like that. Personally, I think zero tolerance policies are a bad idea. In many levels, but certainly when it comes to schools. So, that's a quick overview of student discipline. So just to reiterate, through the idea of in loco parentis, the courts have really given school leaders a lot of discretion in school discipline, especially when it comes to things that you have clearly written in policy and have made students aware of. As long as it's not excessive, as long as it's not done through malice or sadistic reasons, typically schools are going to be allowed to discipline students as the leaders see fit. So hopefully that gives you a little bit of insight into school discipline. There are some links in the modules that will help you, some stuff specifically targeting Oklahoma. So with that, I wish you the best and good luck.